on trial for his murder is pleading insanity, claiming an angel who looked like Olivia Newton-John told him to do it.
Waco AT&T worker in 2016 has been found not guilty by reason of insanity.
Page, as the monster known as the frat boy cannibal, is declared not guilty by reason of insanity.
His plea to not guilty by reason of insanity. We have
a verdict of not guilty by reason of insanity.
Year-old found not guilty by reason of insanity.
Joshua Haken is faking his insanity.
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 Insanity. Insanity.
Insanity.
Reason of insanity.
The insanity defense as a legal concept was born in England in 1843. This is named the Macnaghten Rule. Named after Daniel Macnaghten, this rule states that every man is presumed to be sane, and to establish grounds of insanity, one of the following must be clearly proven. 1. At the time of the act, they must suffer from a disease of the mind, i.e. not knowing what they were doing, or 2. If they did know it, they must not have known what they were doing was truly wrong. It's important to note that there is a difference between pleading insanity versus temporary insanity. Insanity is a mental illness or disease that makes it impossible for a defendant to know that they were committing a crime or to understand that their actions were wrong. Typically, these people will be put into mental institutions for an extended period of time. However, temporary insanity is a defense by the accused that he or she was briefly insane at the time the crime was committed and therefore was incapable of knowing the nature of his or her criminal act. One problem with this is the lack of proof. Since any examination by psychiatrists had to be after the crime took place, the only evidence could be behavior of the accused immediately before the crime. This plea can be used when the defendant believes that they shouldn't be held criminally liable for their actions due to a temporary impairment in their ability to make sound judgment. This is very common with victims of emotional, sexual, and physical abuse. However, there is a huge controversy on when people should plead insanity and when it's fair and when it's not, since a lot of people believe that pleading insanity is a get-out-of-jail-free card. With the knowledge of the insanity plea, it is important to keep these questions in mind as we go over the court cases. 1. Can you trust the criminal justice system to judge what's insanity versus what's not? 2. Is the punishment of the insanity plea justified? 3. Is the insanity plea a valid defense for a crime? The next case is that of Lorena and John Bobbitt from Manassas, Virginia. This couple had a rocky marriage because John Bobbitt would frequently sexually, emotionally, and physically abuse his wife. After John came home from work one evening, he raped Lorena again. This was her final straw. She waited for John to go to sleep and said she was going to get a glass of water. But when she returned to the bedroom, she had an 8-inch carving knife in her hand. She used this knife to sever the penis of her husband, which she did successfully. She then ran out of the house and got in her car to escape his wrath. She drove for a while with her husband's genitals in hand until she became tired of holding it and threw it out the window into an open field. After this, Lorena called the police and told them all of the events that happened that evening, and she was later arrested. After the trial, the jury found her not guilty for reasons of temporary insanity due to insanity causing an irresistible impulse to sexually wound John, and she was court-ordered to go through a 45-day evaluation period in a mental hospital. Some people believe that a lot of people use this plea as a get-out-of-jail-free card, but that's not true. The number of guilty for reasons of insanity are less than 1% in the U.S., and success in being acquitted are far more rare at 0.26% in the United States. So now it's time to think. Is the insanity plea a valid defense for a crime? In this circumstance, it would be, because Lorena endured lots of trauma from her husband John for years, and because of this trauma and abuse, she developed depression and PTSD, which would explain why she reacted in such an erratic way.
On March 30th, 1981, President Ronald Reagan was leaving the Hilton Hotel in Washington, D.C. with a security team. Several shots were fired at him and his security team with Devastator bullets, which are essentially bullets that explode on impact. President Reagan received a ricochet bullet under his left armpit, and several others in his security team were shot. He then spent 12 days in the hospital before returning to the White House.
John Hinckley is his name, John Hinckley Jr., and he changed the course of U.S. history in 1981 when he shot and wounded the president and 3 other people outside a Washington, D.C. hotel.
The defense argued that Hinckley should not be held accountable for the shootings because he was suffering from a major depressive disorder and from schizophrenia. Prosecutors argued that he was sane and should be found guilty because he was only suffering from depressive neurosis and personality disorders. John Hinckley Jr. was deemed unfit to withstand trial based on his mental capacity and therefore pleaded insanity. This was highly controversial as many people did not believe someone who had attempted to assassinate the president should get off scot-free. However, that was not the case. While he was found not guilty by reason of insanity, he spent more than 30 years at St. Elizabeth's Hospital in Washington, D.C. Finally, in 2016, he was released by the courts and did an interview expressing his sorrow about the incident. There was huge public controversy and outcry over the use of the insanity defense. How could someone attempt to assassinate the president and get away with it? How could this defense be used in cases of murders? Here we ask the question, is the punishment, or the lack thereof, resulting after an insanity defense fair or just? The attempted assassination of the U.S. president is a very severe crime that gained tons of public attention. Is it fair that the defendant didn't serve any jail time? There are many acquitted who essentially got off scot-free by using the insanity defense, giving this issue a lot of public controversy. The Hinckley Jr. case led to a changing in the legislation of the insanity defense. Before Hinckley, the burden of proof in federal cases was on the prosecution to prove beyond a reasonable doubt that a defendant was sane. The post-Hinckley reform legislation shifted the burden to the defendant to prove with clear and convincing evidence that he was legally insane at the time of the crime. The question is difficult. How can the victims get justice without potentially posing harm on everyone else?
The next question we pose is, can we trust the criminal justice system to judge what is insanity and what is not? Today, a psychiatrist will perform a physical evaluation and determine if the defendant was suffering from a mental illness during the time of the crime using the Rogers Criminal Responsibility Assessment Scale, which is a lengthy interview and test to determine if the defendant understood the crime they committed. But to be insane, you have to be unaware of the crime as it is happening. But is this test reliable? If someone tries hard enough, could they fake insanity? A case that explains this is that of Steven Steinberg in 1981 in Scottsdale, Arizona. Steven Steinberg stabbed his wife, Alina, 26 times in their home while sleepwalking. When he woke up from this state, he called the police and reported it as a break-in because he didn't realize he was the one who murdered his wife. During the trial, he acknowledged that his wife was killed by him, but stated that he was not criminally responsible due to insanity. Dr. Martin Blinder, a California psychiatrist, testified that the murder was committed under a scenario of dissociative reaction. This is a trauma response where your mind disconnects from your body and you experience temporary memory loss and feeling like you are not yourself. Stephen was then found not guilty by the jury for reasons of insanity and believed that he was not mentally present during the time of the crime. He was not put in a mental facility and is now a free man. Most people believe his wife drove him insane due to the nagging and all the money she spent. During the crime, he was temporarily insane, but during the trial, he was sane. Was his sleepwalking and having a dissociative reaction a valid excuse for brutally murdering his wife? What makes him insane and other people with a dissociative reaction or PTSD not? Did the courtroom effectively judge whether he was insane or not? I believe that his sleepwalking isn't a full excuse to get away with murder. The use of the insanity plea has been a public controversy since 1843 when the first case of the insanity plea was presented. This plea isn't often used, but when it is used, the public always has something to say about it. The biggest frustration is that too many cases that use the insanity defense don't get a long enough confinement. There's also an ethical dilemma that these defendants aren't being held responsible for the crimes they committed. Some people are saying that this defense should be banned because the people with mental illnesses should be tried the same as offenders that don't. I think this is going to a bit of an extreme because yes, they should be held responsible, but the punishments should reflect their mental state, and those with mental illnesses should get the help that they need. The three questions that we presented may never be answered due to the growing controversy and different opinions. Do you think being insane is a valid excuse for murder? Is the punishment justified? And can we trust the criminal justice system to effectively judge what is insane or not? And because of this defense, there are many murderers that use the insanity plea that are free and walking around today. And you may have even met one and never have noticed.